All rise, veuillez vous lever. The International Residual Mechanism for Criminal Tribunals is now in session. L'audience du mécanisme international appelé à exercer la fonction résiduelle de tribunaux pénaux est ouverte. Please be seated.
Your Honour, the interpreters cannot hear you.
My apologies. I'll start again. Good afternoon, everyone. And that extends to everyone who's here both in person and virtually. I'm conducting the hearing from the mechanism premises in The Hague, and I am joined by Judge Elbaz and Judge de Guzman, who are participating via video conference link. Mr. Kabuga is also appearing today via video conference link, and it's been confirmed that he is receiving interpretation in Kinyarwanda. Today's hearing is being held in what for the tribunal is a new venue following the closure of Courtroom 1. As the mechanism continues to move towards the completion of its mandate, we must adjust, adapt, and innovate while still maintaining the highest standards. As we close one chapter in the lifespan of the mechanism, we start another here today. When I first came to the ICTY premises in this building 21 years ago, I instantly recognized the courtroom as a typical adversarial courtroom in a common law justice system, and was able to fit in without any introduction to the courtroom. And I'm delighted to be able to say that the same impression struck me as I came into this room today. It is set up exactly as one would expect a courtroom in a domestic jurisdiction dealing with equivalent business. I applaud the efforts of the registry, in particular Dragan Cvetkovic, for the technical support in making all the necessary modifications to ensure that this hearing takes place in a venue which functions in a way that is similar to that original courtroom. While there will be no live feed, the recording of the hearing will be available to the public shortly after we conclude. As usual, the public transcript of the hearing will also follow shortly thereafter, after the normal review process. The new venue also includes a small public gallery on my right, similar to the small gallery in the old courtroom 2 of this building. During the hearing, should it become necessary to go into private session, the audio feed for the individuals in this gallery, who include, I understand, representatives of the press, will be briefly disconnected. In my view, this venue and the protocols put in place will enable these important hearings to continue to be held in public while ensuring respect for Mr. Kabuga's fundamental rights. I'll now take the appearances for the parties. Ms. Begg, would you please identify who represents the prosecution today?
Good afternoon, Your Honor. Laurel Begg for the prosecution. I'm joined in the courtroom by Christine Keller and our case manager, Dennis Tourahan, and I'm joined remotely by VTC with senior trial attorney Rupert Elderkin.
Thank you, Ms. Baig. And now MICT-13-38, who represents the defence.
Bonjour, Monsieur le Président. Bonjour, Madame. Bonjour, Monsieur. Pour la défense de Félicien Kabuga, je suis Emmanuel Altit et à côté de moi, Julie Hott, qui est notre assistante juridique.
Thank you, MICT-13-38. Now to business. I'd like to recall that on 7th August 2023, the Appeals Chamber issued a decision instructing this trial chamber expeditiously to consider appropriate modalities and conditions for Mr. Kabuga's release. While the trial chamber has been diligently working towards implementing these instructions since these proceedings were indefinitely stayed in September 2023, a solution has thus far not been found, which continues to be complicated by Mr. Kabuga's deteriorating health conditions. With that in mind, today's hearing provides another opportunity for the defence to inform the Chamber of the progress it has made in identifying a state that's willing to accept Mr. Kabuga onto its territory for his provisional release. As is the usual practice, the parties may also and separately raise any matters concerning Mr. Kabuga's health and detention towards the end of the hearing. Since preparation is key to ensuring that court proceedings are conducted effectively and efficiently, I should also note at this stage that I held a case management meeting yesterday afternoon with the parties and the registry to focus today's discussion. Before we enter into any discussion, I will briefly provide a public update on the procedural developments since our last status conference in September. Excuse me. Of particular relevance to implementing the instructions of the Appeals Chamber is that on 14th November 2025, the trial chamber issued a decision finding that Mr. Kabuga is not fit to travel to the Republic of Rwanda. This decision was not taken lightly and comes following litigation that spanned over 2 years and was premised on evidence provided by 4 experts, including one specialised in aeromedical transfers, as well as medical reports from the reporting medical officer of the United Nations Detention Unit. The trial chamber also requested in this decision that European states, especially those located close to the Netherlands and where Mr. Kabuga has made an application for provisional release, reconsider accepting him onto their territories based on his current medical condition. The prosecution has appealed this decision and sought reconsideration of the Appeals Chamber original decision of 7 August 2023. That matter is currently with the Appeals Chamber. In relation to efforts undertaken by the defence to find an appropriate state of release, the trial chamber issued a confidential decision on 7th October 2025 in which it allowed the defence to share Kabuga's medical reports on a strictly confidential basis with the relevant authorities and courts of a specific state in support of the defence's application to be accepted onto that state's territory. Since the last status conference, the trial chamber also received 3 monthly medical reports from the medical officer of the UNDU regarding Mr. Kabuga's health and is expecting the 8th report from the panel of independent medical experts early next year. With respect to the recovery of legal aid funds provided by the mechanism to Mr. Kabuga, slow progress is being made and a working level meeting between representatives of the state concerned and representatives of the trial chamber and the registry took place on 13th November 2025. On 8th December, a note verbal was received from the authorities of the relevant state outlining the law of that state in relation to the matter of Mr. Kabuga's frozen assets. While that completes the procedural update, I believe this is a suitable point at which to ask the registry representative in court whether she can provide any further update in relation to the recovery of the frozen assets, but including in that, in particular, if possible, the registry's anticipated next steps following receipt of that note verbal from the state concerned on the 8th of December. Now, I think, Ms. Kaufmann, you may be able to address that issue.
Thank you, Your Honour. Thank you. Your Honours, on behalf of the Registrar, allow me to present an update on steps taken to recover assets, as well as an update on next steps. Following a working level meeting on the 13th of November 2025 between representatives of the mechanism and the relevant authorities of the state concerned, in which the authorities provided useful information as to the domestic requirements for the implementation of the order for contribution, the Registrar sent a note verbal to the state authorities, in which he renewed his request for high-level meetings to further discuss how the state authorities may support the mechanism in this matter. The mechanism subsequently received a response dated 8th December 2025 from the state authorities, providing written confirmation of the domestic requirements for implementation of the order. Your Honours, in the 8th December response, the state authorities confirmed that proposed dates for the bilateral meetings would be forthcoming. The Registry continues to follow up with the relevant authorities in this regard. Please be assured, Your Honours, that the Registrar and the Registry consider this issue to be an institutional priority and remain firmly committed to advancing this matter. As such, the Registrar is not close to any approach, including an assessment of the feasibility of engaging domestic counsel. Such an approach requires careful consideration. The Registry will report to the Chambers as soon as there are any updates to provide in relation to this approach. In sum, Your Honours, the Registry considers that good progress has been made and that the mechanism has further concrete avenues to explore to ensure that this matter is resolved as soon as reasonably possible. Thank you.
Well, I'm grateful to you, Ms. Kaufmann, for that update, but can I say from my own perspective, and it's a limited one, I acknowledge, but it is well known in the legal profession in general throughout Europe that there are many counsel experienced in international affairs. That experience and expertise is not confined to those who practice before international courts and tribunals, but it's been widely not only practiced but essential in Europe because of the number of states involved, the interaction among these states, how easy it is to travel between them, and the issues that so often arise among and between them. And for what it's worth, I'm keen to have this and glad to have this opportunity today to state openly that it seems to me that one avenue that must at least be explored, if not necessarily followed, is that of finding who is the go-to person in the particular subject area that covers the issue of frozen assets and the use of these, and more particularly the release of them, which appears to be the principal obstacle. I hope that careful consideration will be given to these thoughts. I also acknowledge that there are other avenues, many which may be pursued, but hopefully only those which look as though they are likely within a reasonable time to advance the tribunal's interests in this area will be followed. Now, does the prosecution wish to make any comment on what's been said so far on this issue?
Not at this stage, Your Honor.
Thank you, Ms. Bigg. Maître Altit?
Non, merci, Monsieur le Président.
Thank you. I'll turn now then to
No.
the question of provisional release. The defence has so far filed 34 confidential progress reports on its efforts to secure Mr. Kabuga's provisional release. In its last progress report, which was filed confidentially today, the defence informed the trial chamber of developments related to administrative proceedings it is pursuing in 2 European states. Maître Altit, now seems like an appropriate time to hear updates from you or anything you may wish to say on your efforts to secure an appropriate state for Mr. Kabuga's provisional release. I would prefer to remain in public session to the extent possible. And in view of the fact that we've received already a detailed confidential report this morning, it should be fairly easy for you to refer to matters not already in the public domain in more general terms and convey the full impact of what and meaning of what you propose to or of what you indicate to the chamber. However, if it turns out to be necessary, we can go into private session to avoid disclosure of any sensitive or confidential information after your public update. But let's see if we can get through it publicly. Maître Altit.
Merci, Monsieur.
Thank you, Your Honor. Your Honor, let me start with France. Regarding France, first of all, we have what we call the implementation of your decision of the 14th of November 2025. On that basis, the French expert with whom we're working approached the ministries concerned in France, conveyed your decision to them, and made sure to agree with them on the start of discussions on the tangible modalities of Mr. Kabuga's arrival in France. To this date, I can tell you that the documents were received and then conveyed to the relevant departments as a matter of priority. The discussions are continuing with various stakeholders within the ministries concerned. Of course, we hope that these discussions will be fruitful, but however, it is, of course, too early to give you an idea of their nature. Next. As you know, we have started 2 proceedings in France. I'm going to speak about one of the 2 proceedings that is well underway. It's an administrative proceeding. On the 10th of December, we received, or rather on the 12th of December, we received a decision dated 10th of December by a judge of the Administrative Appeals Court of Paris. So we're not talking about a judge who's looking at the merits of the case, but a judge whose job is to sort out cases and decide which one will be ruled on and which ones won't. From this judge's perspective, and I would like to quote him, if you may, the measures asked for would require that the French state intervene before the international mechanism to organize the provisional release of Mr. Félicien Kabuga, obviously, under Article 68 of the Rules of Procedure and Evidence. Therefore, says the judge, I'm still quoting, such a measure cannot be detached from these international criminal proceedings, neither from the conduct of diplomatic relations of France. End of quote. Therefore, we asked a lawyer before the Council of State. Those lawyers are the only ones who are able to intervene before the highest jurisdiction within the administrative order in France, what he was thinking about such a decision. He said that we needed to introduce an appeal, which is what we did yesterday on the 15th of December. Why? Because considering, as this judge did, that the request would be that France would have to have a determined behavior in its relations with the international mechanism is in fact a gross mistake that should be rectified by the Council of State. The filing of the appeal opens a time period of about 3 months, during which the complainant will file a memorial. The interesting part in this is that the Council of State could actually rule on the merits without having to send the case back to an administrative court. So, in fact, it could allow us to speed up the proceeding, and within a relatively short time period, approximately 6 months, we would finally have a decision on the request, on the position of the French authorities regarding Félicien Kabuga's request. I would like now to move to the request that we have introduced before another European state.
You do that, MICT-13-38, the 6 months that you just mentioned brings another shudder through my body. Who calculated that as the likely period necessary before any decision relevant to this court might be made?
Alors, Monsieur le Président.
Well, Your Honor, there is a first time period of 3 months during which we need to file a memorial. Given the urgency of the situation, the lawyer before the Council of State will try and file this memorial as soon as possible. And then, of course, there will be a response. The lawyer will try and make sure that this response is received as soon as possible. But, of course, this will be out of his hands. However, he will do everything so that the proceeding goes as fast as possible. And what is interesting here is that the proceeding, of course, will not last forever, because the question on which a decision will have to be made will be relatively simple. Therefore, the lawyer before the Council of State said 6 months at best, if everything goes well. But it won't be very long. It won't be as long as, for example, something that would be happening before the administrative court, which then contacted the French administration, which was not responding. No, in this particular case, things are much more straightforward and simpler, and things should go relatively fast. However, of course, these are legal proceedings, and there could always be some setbacks.
MICT-13, you've referred to two, I think, stages involved here. One is deciding whether or not the appeal is well-founded, and the second is to decide the question itself. And you're suggesting that both these questions can be dealt with by the Conseil d'État. Is that correct?
Alors, je vais préciser.
I'm going to clarify, Your Honor. The first step, the referral of the case to Council of State, has already happened. It was already done yesterday. So that referral is done. from that point, there'll be 3 months. 3 months will be given to Félicien Kabuga to file a memorial. We are going to try and make sure that this time period is shortened, of course. That's what we want to keep short. But then, of course, we'll have to wait for the response from the administration.
If I may interrupt you there, the initial issue, is whether the decision that no action can be taken has to be overturned. Is that right? You've already indicated that the opinion has been expressed that this is something which is not for the court because it involves the intervention of state authorities and is a matter of international diplomacy. So that has to be shown to be wrong, first of all. Is that correct?
Absolument.
Yes, absolutely.
If that's successfully established, are you saying the same person goes on, the same tribunal then goes on to make a decision on the issue which is the subject of the case?
That's exactly right, Your Honor.
Does that mean that both are done at the same time, or does it mean that there will be a gap in time between the procedural decision and then the decision on the merits?
Si il nous est donné
If it is found that we are right on the procedural aspect of things, then the Conseil d'État, the Council of State, may and will, as far as the expert is concerned, most probably rule on the merits. But of course, we need to be found right as regards the procedure itself, the procedural aspect.
All right, thank you.
Alors la deuxième.
The second point, Your Honor, is the second state, in which we have taken a few steps already. I will start with the actual procedure, which is ongoing. I will not provide any particular details since we are in open sitting, but I can tell you that things are progressing well. That the deterioration of Mr. Kabuga's health condition, which is an important aspect for the judges, to be taken into account by the judges. Was brought to their attention, and all the necessary information was provided to them in that respect. And of course, we've also given them the decision issued by this court on the 14th of November, which I hope will also help them see the situation in a very clear manner. That's about everything I can say in an open session. However, I would like to talk about the other efforts that we've undertaken in this second country. There is a body, an administrative body, but a body that is also taking into account the political environment, if I understood well, and we are in direct contact with this body or entity. We, of course, we have provided them with the 14th of November decision of the court. We have provided answers to their questions about the possible consequences of Mr. Kabuga's presence on their territory. And I believe that they now have a clear overview of the situation, since they also said that the deterioration of Mr. Kabuga's health condition could be a reason to rule on whether he should be admitted on their territory or not, but at least that it was a positive reason for them. Discussions are ongoing, and of course, As soon as we have more information, we will convey them to you.
Anything further? Do you see any need to go into private session for anything you want to say to us?
Monsieur le Président,
Your Honor, I think I gave you a general overview of what we're doing in a public session, but if you wish us to go more into details, then of course I'd be happy to move to private session.
There's no need for that unless you feel there is more that needs to be known by the tribunal. If you're content that you've disclosed all that it's appropriate and necessary for you to disclose at this stage, then there's no need for us to go into any private session.
merci Monsieur le Président.
Thank you, Your Honor. I think I've said most of what needed to be said.
Very well, thank you very much. Ms. Baig, have you any submissions to make on what Mr. Altit's been saying?
Your Honor, just very, very shortly, these efforts appear to be focused continuously on 2 states, and the efforts have proven to be unrealistic. The bottom line is that both of these countries have refused Mr. Kabuga's repeated requests to live on their territory, and the endless appeals are unlikely to change anything given the underlying factual situation. The bottom line for the prosecution is that Félicien Kabuga has no right to live anywhere other than the country of his citizenship, and that is Rwanda. So that is the prosecution's position. Our other submissions are in our written appeal before the appeals chamber.
Has the prosecution made any effort to find out if there are other jurisdictions which would accept Mr. Kabuga as resident on their territory?
Your Honor, that's not the role of the prosecution in these proceedings. So the answer to that question is no. We've not been requested to do that, and that's not part of our role. There is a place that Mr. Kabuga can go, and that is his country of citizenship and nationality, and they have put on the record that they are ready and willing to accept him and to abide by any provisional release orders that Your Honors may make, and it's the prosecution's submission that that's the appropriate place.
And as you know, the tribunal itself has decided that the risk that he would be seriously damaged or killed by transporting him makes it inappropriate for that decision to be taken, and the tribunal here has accordingly decided that that's an unrealistic proposition. So we're left where 3 states in the world have been presented to us as potential homes for Mr. Kabuga. So I simply asked the question out of interest to see if you had somewhere in the information that's available to the prosecution and not necessarily available to anyone else, an indication that there might just be another country that would be prepared to take him. And I would hope that if that was the case, the prosecution would immediately encourage us to look in that direction. I don't regard your job as simply locking people up. I think it's also one of ensuring that justice generally is done. I assure you that the tribunal is desperate to find a place for Mr. Kabuga to go, that he can go to safely and without risk. And I invite anyone who can make a suggestion, a positive suggestion on where we might look, to tender it. Anyone involved in the case at all, and that extends to the prosecution. But if you can't assist me, then that's all I need to hear from you at the moment. Now I'm going to turn to the final matter, the detention and health of Mr. Kabuga. Maître Altit, is there anything you wish to say that's not already been said regarding Mr. Kabuga's health and the circumstances of his detention that you need to indicate to the tribunal today?
Merci, Monsieur le Président.
Thank you. Yes, we saw Félicien Kabuga this morning. The situation is difficult, to say the least. He's exhausted physically. He has very difficulties to focus. But regarding the detention conditions, I must say that they're well adapted. We saw him in the hospital. He's extremely well treated, at least as far as we can see. Giving you my point of view, I really think he's getting the best medical attention. The medical staff is doing everything it can, given his very difficult personal situation.
Thank you, Maître Altit. Now that completes the agenda we have. Are there any additional matters that either council wishes to raise at this stage? Ms. Begg?
No, Your Honor.
Maître Altit?
Non, merci, Monsieur le Président.
Well, thank you.
No.
Thank you to both of you. Before, though, we adjourn today's hearing, I'd like to reiterate, for the absolute avoidance of any doubt, that the trial chamber is continuing with its efforts to implement expeditiously the appeal chamber's instruction to address the release and liberty of Mr. Kabuga. The decision of 14th November on Mr. Kabuga's fitness to travel to Rwanda clearly reflects the real challenges of relocating a person in his condition with serious physical and mental frailty. While this decision is significant, the trial chamber finds itself today no closer to a durable solution to Mr. Kabuga's release. In finding that he's not fit to travel to Rwanda, the trial chamber must remain hopeful that its decision, which illustrates his serious medical condition, may provide another basis that the defense can use to request the assistance of member states to help the mechanism in agreeing to accept Mr. Kabuga onto its territory. Now, separately, I've also been informed that we must mark yet another goodbye to a member of the prosecution team in this case, this time Mr. Elderkin, who is with us remotely. He'll be leaving the mechanism at the end of the month. In my own view, which I am sure and believe is shared by my colleagues on the trial chamber, it's a sad day for this tribunal to be losing what we consider to be the core membership of the team leading this case for the prosecution. First, Mr. Rashid, and now you, Mr. Elderkin. Since this will be your last appearance in court in this case, the judges of the chamber wish to convey our appreciation of your professionalism, skilled advocacy, and unfailingly collegial, courteous, and collaborative approach that marked all your interactions with the trial chamber and the defence. We extend to you our warmest wishes for ongoing success and fulfilment as your career progresses. And now finally, as the holiday season and the end of the year is approaching, I and my colleagues wish to express to the parties our appreciation of the general spirit of cooperation in which you continue to address all issues arising in this case. Our thanks go to everyone who provides support to the trial chamber, including technical services, interpretation, transcription, security, and many other colleagues. This year has demonstrated our collective ability to persevere and to adapt to diminishing resources. Your dedication has not gone unnoticed by the trial chamber. On its behalf, I wish you all the compliments of the season and I hope that it brings joy and a measure of peace to each one of you. The trial chamber is now adjourned.
All rise, veuillez vous lever.